I am praying for 25th.
For what?
For orders one.
Orders.
On 25th one.
All right.
May I pray for listing of a motion matter tomorrow, Your Lordship? On 11th, we have filed it, Your Lordship. We are challenging an order of the register, Your Lordship. Thereby, he has allowed, Your Lordship, some ineligible persons to participate in the election process, Your Lordship, in a cooperative society, Your Lordship. That order, Your Lordship, we are challenging. 17th is tomorrow.
Maybe. Tomorrow, I am allowed to move a motion, my lord. It is regarding amalgamation of two schools, my lord, without valid
Amalgamation of?
high school and ME school.
Go to the appropriate bench. This is not bench 5 matter.
Sorry.
Yes. We have one.
May
Yes,
please, Your
Mr.
Lordship. My Lord, I beg to mention item 2, my Lord. We filed an affidavit. The state has filed an affidavit this morning. If I may please be permitted to bring it on. Deeply obliged.
I'm praying for listing one motion matter also tomorrow. Arvind there also the eviction matter. The eviction will be carried out also on.
My lord, I have also similar prayer, my lord. My lord, particularly election of a my lord, cooperative society, my lord. The election is conducted supposed to be held on 17, my lord. So I have highly yesterday, my lord. So my
When was it notified?
my lord,
Election was notified when?
my lord, on 9th, my lord.
Then why have you come now?
My lord, some documents were lacking. That is why, my lord. And Friday, my lord. Tomorrow, my lord.
Friday.
Friday, my lord. Okay.
Lordship, we had,
Friday is tomorrow. Yes.
Lordship, will please call on record the affidavit in reply we had filed for item number 1. We had filed it yesterday.
Yes.
Also, Lordship, prayer for request of listing for an admission item tomorrow or next week.
What admission? What is the matter?
Lordship, writ petition of retired Justice D. Biswas. He had, it's regarding an income tax matter, Lordship. He had been paying his dues, but he has still been
Monday.
getting notices.
Monday. It can wait till Monday.
Lordship, Tuesday, if it's
Tuesday.
I should not be here on Monday, my lord. It may be Tuesday or this day, my lord.
Tuesday.
Yeah, please, Your Lordship. I beg to mention for listing of two WBC matter. Both the matters are already amicable settled. So matter may be withdrawn on the.
Please, Your Lordship. Lordship, I beg to mention item number 3, Lordship. Although it's a partner matter, Lordship, central government instruction is required. Last occasion, my senior sir has filed one affidavit, Lordship. Bring to the some documents, facts. They have said that the production which was commenced after 2017 also, the central government has given the subsidy, Lordship. So I returned to the ministry, Lordship, but communication lapse on my part. I have only yesterday I have communicated. So Lordship, at least 2 weeks time, I also take consent. If Lordship that come in a positive way, then Lordship hearing is also not required, Lordship.
How much time do you want?
Lordship may give us 2 weeks time. In the meantime, I will.
Then after that, you will again ask for 2 weeks. So we'll put it at 4 weeks.
Lordship.
4 weeks.
Lordship.
If it has waited for.
12th of my lord, that can be October.
Sorry?
12th of October, my lord.
All right.
Lordship.
When did you file the affidavit?
I filed the affidavit on my lord.
20.
No, prior to 10. I think 9/8/2023.
9/8.
The matter was registered on 10/8.
All right. Mr. K. Agarwal, learned senior counsel for the writ petitioner is present. Mr. K. Gogoi, learned CGC appearing for the respondent numbers. You have for respondent numbers?
Lordship, I am for Asuna 1, Lordship. 1 and 1, only 1, Lordship.
Your lordship,
Appearing.
I'm sorry, Lord. Your lordship has already my lord, passed that order on 10/8/2023. My lord, that I have filed an affidavit. They may like to, my lord.
Appearing for the respondent number 1 submits that instructions as called for on the affidavit filed by the on the additional affidavit filed by the petitioner is still awaited. Having regard to the fact that the issues raised in the additional affidavit would have a crucial bearing on the outcome of the writ petition. Mr. Gogoi seeks 4 weeks further time to seek instruction and file rejoinder if so advised. Full stop. Mr. A. Kalita, learned standing counsel, Industries Department, and Mr. R.K. Batra, learned counsel for the respondent number 9 are present. Since the prayer of the learned CGC is not opposed, same stands allowed. Let this matter be listed again on 12th of October 2023 as a fixed item.
It was filed on 8th August.
Affidavit filed on 8/8.
I'm okay.
Additional affidavit filed on 8/8/2023.
Two affidavits have been called for, my lord, now. My lord, only limited prayer, my lord, here, actually. Our prayer is, my lord, that I have filed a complaint for a CBO and I have filed a complaint against him also, my lord. And there, my lord, he has been actually censured. If your lordship will take up the affidavit of my lord, that's not 4. At page 91, page 91, my lord. Total.
Mr. Sahiwala, perhaps there is no need to go very deep into the legal
No,
procedure.
not necessary. Only one.
You can't file this writ petition. You don't have any locus. Are you moving a PIL?
No, not PI, my lord. I am only on the point, my lord, that the person against whom a censure order has been passed, he should not inquire my matter, my lord. Because at that, my lord, the CBC has virtually passed an order.
Inquire your matter means you have made a complaint.
Yes,
You're alleging corruption.
my lord.
Yes,
Some,
lodge an FIR.
my lord.
Lodge an FIR.
No.
There is a, these
There
are
is-
matters we can't
My lord,
enforce through
there
writ
is a
petition.
procedure, my lord, the CBO is there, my lord. So we have filed a, yeah. But now he has been inquiring into. My lord, only thing, my lord, I don't want anything, my lord. Is it, my lord, natural justice violation, my lord? Because the person who is biased now.
You
because
don't want anything, but the court is saying you will not get anything. What do you have to say on that?
Only this aspect.
Mr. Sahiwala, these are matters we can't, this is stretching things too far.
My lord,
You have filed your complaint. If the NRL authorities feel that it is not worth investigating or inquiring into the matter ends there. But if you think there is an element of non-cognizable cognizable offense, then you have to lodge an FIR and then we'll see.
my lord, that is another aspect of matter. Now CBO, my
Otherwise,
lord,
it will create a complete chaos will descend in these matters. If individual officers feel that in their perception something is going wrong and the court should direct so-and-so to inquire, so-and-so to stop from inquiring, what is the jurisprudence you are talking about
your
ultimately?
losses, my lord.
What is the jurisprudence?
No,
Let us
my prayer may
understand
be-
that.
my prayer may be seen, my lord. What I have.
No, Mr. Sahiwala, I am asking a very simple
Yes.
question.
Yes.
What is the jurisprudence on which we are to act on these prayers? That's all I'm asking. Tomorrow, anybody can come and file a complaint saying that, look here, something is going wrong. Issue a direction, so-and-so should inquire, not so-and-so, and so-and-so should stop from inquiring. How are the courts supposed to act on this
My lord,
request?
I'm not asking the court also, my lord, to do that.
If
My lord,
you,
only pass an order to Respondent 4, my lord, to pass an appropriate order. Because Respondent 4 has already passed an order censuring the Respondent 6.
Mr. Sahiwala, I am asking you one thing.
Yes.
The other day, this matter came up, I think
Yes.
2 days back,
My lord.
and the court had an occasion to peep into the.
Yes.
I am asking you, if you want a reasoned order, I will pass it. But if you want to withdraw and file a lodge an ejahar with liberty to pursue remedies, then we will not make any observations. Otherwise, the court is of the view that these are not matters which come within the domain of petitions under 226. There is no right of the petitioner which can be enforced here.
My lord,
This is his perception.
I said
The
take
courts
instruction.
cannot drive perceptions of
My
individuals.
lord, I said take instruction in that matter.
Hmm?
my lord. I said take instruction in that matter.
Then you have to do it in next half an hour. This matter was fixed today for disposal. And the only reason is we don't want this kind of matters to remain pending. We don't want. These are all arm twisting, techniques. It is his perception. He cannot enforce his perception through a writ of mandamus. In his perception, some wrongdoings have happened. It is for the higher authorities to decide whether it has happened or not. He cannot say that I feel there is something wrong happening, so issue a mandamus going into the matter. These are in-house.
I have not asked for
No,
that. my lord.
whoever
I have
inquires
not asked for
doesn't.
that only. My lord, only, my lord, I want that the person who has already been censured, he should not receive the matter. That's
You
the-
want.
my lord,
We are not concerned with what you want.
Yes.
We are concerned with, do you have a right which needs to be enforced in this writ petition. That's the only question we are concerned. As court of law, we are not to get into these things. Somebody wants this, somebody wants that. Why you want, what is the agenda behind? We cannot get into all these things. Merely because you want, should we do it?
No,
You may want
I'm not-
anything.
I am not asking. for-
And then
Necessarily, my lord.
want perhaps is not the right expression. You have to show that you have a legal right. And what is that legal right? If you think that there is a corruption which has taken place, it is clearly a cognizable offense under the act, under the law. You must lodge an FIR and set the investigating machinery into motion. Why haven't you done it? Why haven't you done it? So does it not raise a clear question on the bona fide of the petitioner?
Ask, my lord, the,
I'm sorry, I have to put these hard questions.
no, no.
These matters are hard.
Before lodging that.
And we will also ask him, but then,
Some
Pointed-
inquiry, some inquiry is necessary, my lord. Otherwise, my lord, this. It cannot be-
all right, you complete your arguments, Mr.
My
Sir.
lord, after half an hour, you know.
Hmm?
After half an hour,
After half an hour, you are free to argue, and in which case we will pass a reasoned order.
my lord.
But if you want to withdraw with liberty to pursue other remedies, then it will be a order simpliciter of withdrawal. That's all.
My lord.
Nothing will be written here. But the court is of the prima facie opinion
Right.
that there is no right of the petitioner which can be enforced here. These are his perceptions and he is entitled to his perception, but he cannot bring it to the court of law.
Right.
Mr.
Yep.
Chaudhary, let him have
Madam,
his instructions after half an hour.
Madam.
Please.
We filed the affidavit, it's on its way. If it may please be passed over for the time being.
What is the matter, Mr. Goswami?
It came up before Lordship earlier also.
Ah,
Concerns below the withdrawal, abrupt withdrawal without any information of a PSO who was given for several years on a perception of threat. To
So,
his,
Mr. Goswami,
Yes.
let me put it to you in this way.
Yes.
We are on the legal principles.
Yes,
The court cannot decide whether
No.
a PSO should be given or not.
no,
The court will only see whether the procedure adopted is in accordance with law or it is an arbitrary exercise or malafide exercise of power, right?
correct.
So their case, if I could recollect from the previous day's hearing,
No,
They are saying-
something more has come.
something more has come.
Yes.
Madam, we have filed a fresh affidavit, but I
Ah.
could not file it yesterday, this morning. we
Your
have filed.
lordship's last order of your lordship. It came before
Can it
another
be taken
bench.
after
when
some time?
your
The
lordship-
affidavit is yet to come.
No, no, it's all right.
the time.
I
That's all
will
right,
come
that's all
to
right.
your last affidavit at the last, don't worry.
Let me understand what. it is.
Yes, your lordship, when the matter came up, first occasion it was adjourned, seeking time to bring the instruction and all that. Second time, they said, we have received the instruction, they wanted to show your lordship the instruction, your lordship very rightly said that file your affidavit in the instruction. That affidavit has come. And I want your lordship to have a look at it. I think that will,
But it is not on record.
no, that affidavit is already on record earlier.
And then
But-
today some other affidavit.
That is because the last order of the court, which came before Justice Borua, they wanted to file a seal cover. They have now filed an affidavit. I don't know about the
Seal
seal
cover
cover.
also has come.
Oh, I see.
Okay, kindly bear with me for 2 minutes.
Yes.
Let me read the last order.
Yes, yes. What is it? Read.
Yes.
Because your lordship's orders are, there are two orders, 23/8/80, 2023 and 28 August 23. There are two orders of your lordship.
Yes.
And then 28/8,
Yes.
pursuant to that order, my lord, they wanted to show the instruction. Your lordship said that you file an affidavit. Therefore, that affidavit pursuant to your lordship's order of 28/8 has been filed. And I want
Yes, please.
just to so that your lordship, because that indicates the proceedings of the SRCC. Kindly turn, my lord, only one document
Yes.
at page 74. The interesting part is also there at paragraph 4 at page 71. I will not take your lordship to the pleading, but I am just indicating the nature of the affidavit your lordship is getting. That with regard, paragraph 4 at page 71, that with regard to the statements made in paragraphs, all of these which are mentioned, my lord, up to 34 of the petition, I have no comments to offer. And I will indicate, my lord, that the allegations which are made specifically with regard to certain areas of the state, they also admit in their affidavit, yes, there is some amount of improvement, but there are some amount of.
So, the threat perception of the petitioner is specific to certain areas.
Yes, kindly have a look at SRC document itself at page 74. This is
It's,
part of the SRC.
Yes.
Extract of SRCC decision dated 21, kindly see the date below, 21/1/22 and 31/1/22. And our order of withdrawal comes in August 23, after about a year and 7 months. Now, apart from all that, kindly come to comments of SP, DCP, SI and District SP. He has said at present, the existing security may perhaps be continued. That was his view. Recommendation of CP, that is Commissioner of Police, Joint CP, Guwahati, DIGP, agreed. The second man agrees, who are on the spot in Guwahati. Recommendation of PRG, which means Miller Protection Review Group, of 15/12/21, existing security cover to be withdrawn, and approval of SRCC dated 31/1/22 agreed.
So the petitioner's threat is from any particular extremist group? The threat perception is
Yes.
from what, which is that group? Which is that group?
Yes, Miller, that group, Miller, particularly, his operations are extensive within the state. It is Karbi Anglong, but Karbi Anglong, we have given the annexed the certificate, the protection letter to him, that it will be different security will accompany you. That was given. Secondly, my lord, the Union of India granted a 9 mm pistol, which is not given to the civilians normally. And it has been extended right up to 26. These are pages 42 and 43. After an independent assessment of their own perception. Thirdly, my lord, the situation was that he was sought to be kidnapped, which is admitted, and police somehow managed to abort that attempt. 2 of his employees are still missing. He is having threats from different organizations at different places, particularly Arunachal and Tinsukia. And that was alleged in paragraph 15 and 16 and 17, and which your lordships will see. I'll just read out those 2 paragraphs below. And one of them is not even without denied. And even
Paragraphs 13 and
15 and 17. It is spread out in various factors, but specifically here. Para 15 at page 16.
yes.
That it is apparent from the aforesaid incidents that the petitioner is in constant threats. Even the employees of the petitioner's officers are being targeted. Moreover, the petitioner have to visit the militant affected areas regularly for his business. The petitioner has to frequently visit remote places, especially Karbi Anglong and Kharsang, which is at the border of Tinsukia, Assam, and Arunachal Pradesh. Be it mentioned that extremist groups like NSCN-K, NSCN-IM, and Alpha are still active in those areas. All along, the petitioner has remained targeted by such groups, and as such, there is strong possibility that these extremist groups may target the petitioner for ransom, and hence there is strong apprehension and endangering the life of the petitioner and his family. Further, this is common practice among such groups to demand for ransom from businessmen who are operating their business in those areas. This paragraph 15, if your lordships have a look at paragraph 4 now, without comments. I'll read 17 also, but I just wanted to show from paragraph 14. Paragraph 4 of their affidavit.
Yes.
15, no comments. Then kindly turn to page 17, para 17. And I'll show their reply, which your lordship will get at page 73, but para 17 at page 17. That the petitioner begs to state that the petitioner has experienced threat calls from NSCN, K, NSCN, IM, Alpha, and NDFB militants, and attempts of kidnapping, extortion, amongst others, have been tried in the near past. Especially during the festival season, the outfit organizations are in requirement of financial assistance and support. And since the ensuing Durga Puja is at the doorstep, there is every possibility that the petitioner's life is in imminent threat. As such, the act of abrupt withdrawal of the PSO from his duty without prior information or notice, or without assigning any reasons whatsoever, has been causing immense mental pressure on the petitioner. Petitioner's free movement has been restricted, and now he apprehends imminent threat on his life and liberty. The petitioner all this time was hoping that the PSO would be restored back, since it has been done in the past, but to the shock and surprise of the petitioner, even after a lapse of 15 days, then it goes on. This is, my lord, reply is at page 73, para 9. Kindly have a look. Huh? No, this particular is at page 73. Para 9, no? para 9. This is one of the paragraphs, my lord, dealt with. That with regard to the statements made in paragraph 14, 16, 17, which I read out, 16 also I read out, and 19, 20, 21, 23, 24, 29, 29, 30 of the petition, I say that presently the security scenario in the state has considerably improved, and the threat to erstwhile police protectives has diminished to a significant extent. During the last 2 years, in view of the improved security scenario, police personnel detailed as personal security have been withdrawn from 410 protectives. Moreover, all extremist groups, NDF, Adivasi group, Bengali, Abha, Gorkha militants groups have surrendered and disbanded themselves. Hence, as per the decision of the SSC meeting held on 21st, 1, 22, and 31/1, the petitioner's PSO was withdrawn. Therefore, my lord, your lordship now see the position. So far as that part of the pleading is concerned, concerning, my lord, that Kharsang area, Tinsukia area, and the Alpha activities, there is no denial at all. All that they are saying is that the overall picture of the state has improved. Nobody disputes that. I am concerned as an individual with regard to my safety. You may have improved. Many organizations may have entered into agreements with your
So,
agreement,
is
but
there
it is
any-
also your case.
Is there any basis for this apprehension?
My lord,
I mean, what I'm asking is, why can't all the businessmen of
my
Assam
lord,
come and say
my
that?
simple answer is,
Hmm.
would, my lord, the SP, the Commissioner of Police, the DIGP, say there is a personal threat without any basis?
No,
Are
I'm asking is,
You know,
supposing all the businessmen in Assam comes and says, give us a PSA,
my lord, all the-
how do you distinguish it?
My lord, I quite see what your lordship is saying, but let us be realistic about it, my lord. Has all the businessmen come before this court? No. How many of them have come? Your lordship can count. And para 5 of our affidavit, of theirs. They admit, yes, your lordship.
What I'm asking is, has any incident ever happened?
In my case,
Yes.
my lord, it is an admitted position. I was thought to be a kidnap which was foiled by the police,
When was it?
27, 28. Thereafter, my lord,
27, 28 of?
yeah. I have been given, we have been given protection for a period starting from 2008. Therefore, it is continuing. Then 2009, Karbi Anglong, when we visited, they gave us that protection of a special person during the visit and their operations at that time. That is continuing. Then, my lord, the 2 employees vanished in 2019. We have been asking for a CID investigation and everything, nothing has been found. And, my lord, the threats and ransoms, these are all quite well known, they go on. And if I am targeted, now I have been, then in 2015, the Union of India, my lord, gives that pistol, which is not normally given to a civilian. And it has been extended till 2026 after assessment by them. Page 42 and page 43, kindly have a look. Kindly turn to page 42.
Yes.
It is from the Union of India. This license has been issued for the possession of 9 mm PB pistol under threat perception basis for self-protection with all India validity subject to state local restriction with 30/50 emanation as per so and so 11/5/16. Then next column, your lordships will find at page 43, the extension order which is there. At page 43, below. The date on the right hand column. This is up to 26/5/26. So it is not, Milord, as if he is coming out of his own fanciful obsession. There are two governments which have given protection to him. And you are withdrawing even after that meeting of 31/1/20.
So you are saying giving a pistol license is some kind of a protection?
Obviously, Milord, 9 mm is not normally given to civilians. High degree of threat. That's why, Milord, it was granted. Not otherwise, Milord. It's a central agencies have also analyzed and given before that. And
Is the Union of India party here?
no, Milord, they have not taken any step. Huh? Para 5 kindly of the affidavit of the government, kindly have a look at page 71. That with regard to the statements made in para 4 of the petition, I say that at present the security scenario in the state has considerably improved and its threat has diminished to a significant extent as all the extremist group have signed agreements as disbanded themselves except Alpha I, whose activities are restricted to a few districts of Upper Assam. Therefore, considering the improvement of the security scenario in the state, the Security Review Committee referred to so-and-so on so-and-so passed the order. Therefore, my lord, the fact that Tinsukia and Upper Assam, the Alpha is active is admitted by them.
So will you be satisfied if an order is passed to provide PSO as and when he visits these districts where the Alpha is active?
I can see your lordship's point. Your lordships will kindly see, let us take a practical view of the whole matter. He is a businessman. He has just got the security clearance for the helipad aviation, helipad service within the state. And that has been given by the central government to him, that security clearance. And therefore, he has to move about in all these places. So all these places, the Alpha is not only confined there to Upper Assam, they can come anywhere else, to and I am covered by your lordship's judgment, which has followed the Supreme Court judgment from West Bengal. The assessment of the particular person about the threat is a very cardinal principle to be taken into account, because he is the man who is having that perception. So his perception of threat.
Which judgment you are referring to?
Yeah, I want to show your lordship's judgment and also the Supreme Court judgment. If your lordships kindly have a look at the Supreme Court judgment, which is, my lord, at page. No, I'm giving the copy. Compilation is given, no? So move copy it up. First, take the Supreme Court judgment, my lord. And then I'll come to your lordship judgment. First is Supreme Court, my lord, this is 2015, volume 14, SCC, page 599. I think we have given the online copy. If your lordships will kindly turn. Kindly turn to page 6. Para 6 below. Para 9.
Yes.
Para 7, my lord, the report of the police is noted. Last sentence, my lord, if your lordship see. We have during the course of hearing, para 7 I am reading, my lord. It was vehement contention of the learned counsel for the state of West Bengal that security can be provided free of cost only to such an individual who has actual threat to his life, and that since there was no threat against the life of the respondent, he could not be provided police protection free of cost. Rather than accepting contention advance on behalf of the state government on the basis of submission advanced during the course of hearing, this court by a motion bench order dated 5/1/15 directed the state government to re-evaluate the threat perception of the respondent and to submit a report to this court. In compliance with the aforesaid direction, the Superintendent of Police 24 Paragana, West Bengal, submitted a report to this court dated 4/2/15. We have perused the same. A perusal of the above report reveals that the appellant was afforded an opportunity of hearing, and thereupon his assertions were verified. It was eventually concluded that there was no threat perception to the life and liberty of the respondent. A copy of the aforesaid report dated so-and-so was furnished to the learned counsel for the respondent on 9/2/15. During the course of hearing today, learned counsel for the respondent invited the attention of this court to various complaints made by the respondent depicting threat to his life and liberty. We have given a thoughtful consideration to the matter in hand. It is not possible for us to accept the aforesaid complaints on their face value, nor does this court have the expertise to draw a conclusion whether or not there is actually a threat to the life and liberty of the respondent. The only recourse open to us to determine the threat perception to the life and liberty of the respondent was to call for a report from the concerned superintendent of police. The aforesaid procedure was adopted, and the report dated 4/2/15 has been received, which depicts no threat perception insofar as the respondent is concerned. We find no justification for not accepting the report. This is the report of the Superintendent of Police. Then kindly see, Miller, para 10. Despite the conclusion drawn in the report dated 4/2/15, learned counsel for the appellant states that the state government would be ready and willing to provide police protection to the respondents. However, the same shall be at his own cost. This is the appellant before the court is state of West Bengal. It is a submission on behalf of the state of West Bengal that if he pays, will be prepared to pay his give him security. Now see the relevant paragraph 11. Based on the factual position noticed above, we are satisfied in disposal of the present appeal with the following directions. 1. It shall be open to the respondent to furnish further details to the police authorities insofar as the threat perception to his life is concerned. This liberty shall be available to the respondent as and when he perceives such threat. When such a representation is made by the respondent to the police authorities, the same shall be examined and a decision shall be taken thereon within a week of the receipt of such representation. In case it is concluded that there is a threat to the life and liberty of the respondent, he shall be provided free protection. Then number 2, irrespective of what has been directed by us as herein above, and irrespective of the conclusion drawn by the police department, it shall be open to the respondent to claim police protection based on his own threat perception. That's the crucial part. That is our right to life. That I, as a citizen, only can perceive a threat if there is one. In case he chooses to do so, the police authorities shall provide police protection to the respondents and charge him for the same. Therefore,
So your
irrespective.
client is also willing to pay for that.
Yes, absolutely. We have said that. Para 22, we have given that undertaking. Page 22, I think. Page 22, para 21, it runs to para 22, I think. It starts at page 21, para 22. The petitioner begs to state that the petitioner has strong apprehension of threat perception to his life and property, and therefore the petitioner is seeking protection from the respondent authorities. Be that as it may, the petitioner undertakes that irrespective of the conclusions drawn by the respondents as regards to threat perception to the petitioner is even ready to bear the cost of such protection if provided by the respondent authorities. So it's absolutely clear. That part is clear. And the Supreme Court judgment clearly says that you can't ignore the threat perception of the person who is seeking that protection. You may have your own views, but here, Miller, kindly see the situation. Of the SRC members, 2 of them agree that the threat continues.
Let us go to that once again. Where is
Yes,
that?
page 74. Page 74. Comments of SP, DCP, SA, District SP. He has threat at present. The existing security may perhaps be continued. Recommendation of one of CP, Joint CP, Guwahati, DIGP, agreed. So, 2 persons are agreeing that there is a threat perception.
One is Commissioner Police and the other?
One is below the Commissioner of Police, SP. First one is the SP. And second one is the Commissioner of Police.
No, where is the first one? I think I missed it.
Below the comments of SP, DCP, SNI, District SP. He has threat at present.
Page number?
74 below NHRA.
After category, you're not sure by that.
All right.
1, 2, 3, 4, 5th column actually. Comments of SP, DCP, SI and District SP. He has threat at present. The existing security may perhaps be continued.
All right. And what is there you want to show in this other judgment?
Yes,
Yes,
your lordship judgment. Kindly have a look at that. This is my lord. Writ petition number 6231 of 2012, dated below 18/10/17. Yeah, then set out. Two grounds were given. One, that the person concerns who are having criminal cases, therefore they should not get protection. And number 2, that there are not enough people to give for this purpose of police protection. Both were rejected by your lordship. And your lordships have quoted A2 petition is into petition.
What has happened to this writ petition, Mr. Majumdar? This is the final order. This order is the final order.
No, this is the interim order. Your lordship said that interim matter is kept pending.
In those cases are pending. I think.
I
Still
don't know.
pending.
Oh, I see. I am told that it is still pending.
Pending.
Any appeal preferred against this order? You may not be aware.
There is an interim order, I mean, those cases are still pending.
No appeal, I think. And even the records were not produced in that case. And your lordships were waiting, and that's why your lordships have said your lordships referred to the Supreme Court judgment, my lord, earlier, and then from a perusal of the materials produced on behalf of the state, I find that those are threat assessment reports obtained from the various police stations during the pendency of the writ petition. The aforesaid threat assessment reports do not disclose the basis on which the satisfaction was reached by the police authorities before withdrawing the PSO earlier issued to the writ petitioner.
All right, I've seen it. Mr. Majumdar, what is your response?
My first submission will be, here is a case where if we go through the pleadings of the entire writ petition, including particularly,
Mr. Majumdar, sorry to interrupt you. Before you
my lord,
unfold,
my lord.
there are only two aspects which has caught the attention of the court. Number one is there are apparently some recommendations made in favor of the petitioner to continue the security. His security cover was earlier given on the individual threat perception, correct, which the materials show that did exist at some point of time. You withdraw that by ignoring the recommendation made or inputs received from the concerned police official, and on a ground that the state's overall scenario has improved. There is no consideration whether his individual threat perception still continues or not. So if the overall scenario has improved, then all security should be withdrawn from everybody. That is a blanket policy decision.
And in fact, we are withdrawing in my lord.
No, you may. But in that case, you come up with a decision which covers everybody. If you are taking decisions on individualistic yardstick, then will it not be necessary for you to also make an assessment as to whether this threat perception of that particular individual still continues or not? If you do not do it, then what are you doing? You are going on a different tangent. He says, I have threat to life. You say the state is now a heaven. Does it gel? Does it fit in?
Well, I'll reply now.
And the other aspect,
My lord.
let us assume that the perception is ill-founded. Let us assume for a moment. If an individual is willing to pay for the security, why has the state got the reluctance to provide it?
And I'll reply to all your lordship's queries. My lord, first submission, my lord, reply to your first lordship's query, my lord. My lord, there is already a policy decision that we will withdraw the PSOs.
Where is that decision?
I'm coming to that. There is no written as such, but it is there. And in fact, the state government is withdrawing PSOs wherever they are thinking it's not necessary. Your lordship will recall, even in from the members of the Foreigners Tribunal, they have withdrawn, but since your lordship has held that individually their threat perception was not considered, they are in the process of considering individual threat perception. But then it has already been made it clear, it has been made clear that we are in the process of withdrawing PSOs.
In the interregnum, has it been restored?
Yes, immediately. Within a couple of days, it has been restored. I've got order. That has been done. Now, so far as this case is concerned, my lord, yes, in the affidavit, we have said that there is overall improvement. And the authority has also taken into consideration that there is an overall improvement of, in fact, it is not disputed that there is overall improvement in the scenario of militant activities. But so far as his case is concerned, his individual case has been individually and separately assessed. And it was found that there is no threat perception. But repeatedly, attempt is being made that in the SSRC recommendation also, in one column we find there is a recommendation. Yes, there are 3 layers of consideration. If the recommendation given by the lower level authority is to be accepted by the PRG and the SSRC, there is no question. Nothing remains in the SOP. What will the PRG do? What will the SSRC do then? It is because the PRG is constituted of officers, I have given in the affidavit manual, of higher rank. They again consider the entire material, then they take a decision. They may recommend, they may not recommend. Only because at some level it was recommended, it is not necessary. That,
So has the SSRC considered the individual?
Yes,
sector?
my
Where
lord.
is that?
yes, my lord.
Where is that?
This we have brought in the seal cover because they are.
That is the extract from the SRC.
No, my lord, in the seal cover, we have to give something more. We have also not seen. But-
No, the contents may be in seal cover,
My lord.
but have you mentioned that in your affidavit?
Yes, my lord.
Where is that
Yes,
statement?
affidavit. It is there for in. Well, page 80, paragraph 12, Lord, may kindly see of today's affidavit.
Yes.
Slightly longish, but I'll just indicate. That while denying the correctness of the statements made in paragraph 4, before your lordship, I just indicate one thing. In the last affidavit that we filed, my lord, there were some gap in the sense that authorities say that with these paragraphs right now we are not commenting. So we mentioned in our affidavit that no comment, and which is now sought to be argued that you have admitted. No, my lord, and this was this aspect of the matter, that there was no comment in respect of some of the paragraphs of the petition. The Honorable Justice D. Barua on the last occasion indicated that you file a proper affidavit. And thus we have filed a proper affidavit denying all those allegations, including the 15 and 17 on which they are placing reliance today, madam. Now, paragraph 12, I am reading, madam. That while denying the correctness of the statements made in paragraph 14 of the petition, I say that security personnel provided by Assam Police PSO to the petitioner was withdrawn on so and so in pursuance of the SSRC committee decisions dated 21/1/22 and 31/1/22. The SSRC is the final decision-making authority regarding deployment of police personnel to a private person as his personal security cover and above the recommendation of the district authority. Lord, will kindly see. Thereafter, the PRG, that is Protection Review Group, this is SRC is above PRG. The said withdrawal is bereft of any malafide intention as there was withdrawal of security personnel from 410 protectees during the last 2 years. And not abrupt as alleged or otherwise. The delay occasioned in withdrawing the PSO from the petitioner was inadvertent and not due to any malafides as alleged or otherwise, and is incapable of being constituted as conferring any right on the petitioner to ask for continuous service of a personal security person as his personal security, even after withdrawal of PSO is recommended by the highest decision-making body of the state government, that is the SSRC, which takes into account individual threat perception and available resources. In this regard, it is pertinent to mention here in that SSRC conducts a comprehensive review of the recommendation of the district authority and the PRG before arriving at its decision in respect of providing security to individuals. In the instant case 2, this procedure was followed. And that I further say that in respect of the recommendation of the private security to the petitioner at the district level, in the present case, the Deputy Commissioner of Police, Security and Intelligence, what he recommended security may perhaps be continued, and thereafter, Joint Commissioner of Police of the Police Commissionerate, what he commented, I agree. There was no specific threat in respect of the petitioner from any quarter whatsoever, including any individual, groups or militant outfits. The PRG was attended by the then Commissioner of Police, Guwahati, who is the controlling authority of the Joint Commissioner, my lord, who said I agree, and Deputy Commissioner of Police, Security and Intelligence. There being no specific threat in respect of the petitioner in the instant case, withdrawal of the PSO was recommended by the PRG and SSRC. The SSRC comprises of the following members. So these members are given down below like last time, lordship. The PRG comprises of the following members: IGP Special Branch, DIGP Security Assam, IGP BTAD, DIS GP, ranges, SIB representatives. that while denying the correctness of the statements made in paragraph 15 and 17 of the petition, I say that in respect of the alleged threats pertaining to Karbi Anglong district and Kharsang district in Arunachal Pradesh from the following militant organizations, namely so and so and so, I say that while Karbi Anglong is in the state of Assam, Kharchang is in Changlang district of the state of Arunachal Pradesh, Assam. Assam police does not have any jurisdiction in Kharsang area of Arunachal Pradesh. Regarding Karbi Anglong, all the Karbi militant groups, namely so and so, are signatories to the respective peace agreements with the government of India and government of Assam in the recent past and have disbanded themselves. There is no discernible activity of the following militant groups: Alpha 1, NSCN NK, NSCN IM, and district of Karbi Anglong during the last 2 years. Since the situation has improved considerably as far as militant activities are concerned in the state of Assam in general, and in Karbi Anglong district as well, no person's security was recommended to the petitioner by the SSRC after a thorough review by both the PRG as well as SSRC. That I further say that with regard to the petitioner's representation, it is so and so received by the authorities allegedly on so and so, it is most respectfully submitted that in the event this honorable court arrives at a finding that the petitioner's case in respect of the threats as alleged merits a review, the state is ready and willing to undertake a fresh review and pass a reasoned decision thereon upon a direction in respect of the same from this honorable court for such review and a reasoned decision thereon. This much also we have indicated.
You have received a copy of this
I
affidavit?
just got it, Milord.
Okay. You want to file any response, rejoinder? No.
No, Milord, the document itself is there before your lordship.
No, but I must ask you this because
Yes.
they have come up with some factual averments. If you do not traverse it, then the court will have to proceed that these are correct.
Milord, I was thinking, Milord, we are asking for an interim order at this stage. Your lordships may give us an opportunity and fix the matter whenever convenient to your lordship, Milord. But an interim order, your lordship passed in that matter also, which I cited. The interim order was not given earlier, but since this was
No,
going
but I
on.
thought this matter has been taken up for final disposal. That's the earlier order.
Yes.
That is the last order.
Not by your lordship, you
No,
know,
no,
that
yes,
Mr. Borua,
yes.
that if it can't be decided, then
So I am hearing the matter of final disposal, I thought. Should not be
you know,
heard.
basically sir, interim prayer you were saying. I
If
think.
it cannot be
It
decided
is
finally.
made correct that an instant matter cannot be taken up for final disposal on the next day. This court would consider the interim prayer made in the writ petition.
No, what I am asking is,
Yes.
the seal cover materials are there,
I
right?
don't know. Your lordships also cannot say that.
All right, so as of now, there is no need to file any rejoinder, is that?
As far as this affidavit is concerned, this doesn't improve the situation from what they said earlier. That Kharsang thing is not in Arunachal. We have said in para 16 that it is on the border of Arunachal and Tinsukia district where the activities are going on from NSCN and Alpha. And that is admitted even in this affidavit. That is not denied. But my
I have got two other orders passed by this honorable court. Both were disposed of by, or one by Honorable Justice Michael and the other by Honorable Justice Borua very recently. In both these cases, when the SSRC ultimately said we are not recommending, this honorable court did not pass any order in favor of the petitioner. I've got those two orders. Those two cases were disposed of very recently, last month.
Puntu case.
All right, then you argue.
I'll conclude.
I am taking up this matter for final disposal.
I don't know, please. I'll deal with whatever is said.
Now, Lordship.
Yes.
So, my lord, so far as the averments made in the writ petition, the allegations made in the writ petition, what I have understood, my lord, there are basically twofold. One, he had earlier been recommended and he had been enjoying the PSO since 2017. Now, in the writ petition, my lord, my submission is very specific. After 2017, he has not been able to give any incident specifying that because of this, I am apprehending or I have lodged an FIR.
2017 or
After 2017, my lord. As far as kidnapping is concerned, my lord, kidnapping was of his two employees. In the averment made in a particular paragraph where he said there was a attempt of kidnapping. He's not saying that attempt of his kidnapping. It's very vague there. Attempt of kidnapping, and he was informed by police. He doesn't know that he was attempted. Anyway, other than this, my lord, Lordship may kindly have a look at his representation, which is the last page of his petition, page 67. Well, I'll show from there also. He just wants a PSO. He doesn't have any threat as such, even according to him. My lord, the Vishwanath Mitra's case of the Supreme Court on which reliance has been placed, it is a totally in a different context. Number one, there the state government has considered that we are going to provide. And thirdly, my lord, that case did not lay down any law. It is in the facts of that case that some direction was issued. Page 67, man. That I am, Lordship will kindly permit me to read it. That I am a businessman with great reputation and fame. Besides, I am also a social worker and my business activities are operated within the border and remote areas of entire northeast region of India. My area of work is spread across different sectors, including various NGOs and trusts. More specifically, as a trustee of Biva Himangshu Memorial Trust to help the needy and downtrodden people. Due to my nature of work, I have to make constant travels to remote locations and sensitive areas within India. Owing to the field of work I am involved in, I am in constant threat from various underground outfits and is bordering states. Absolutely vague, my lord. In fact, there were instances in the past that I had been threatened by Alpha and NDV militants, and attempts of kidnapping, extortion, amongst others, have been tried in the near past. Besides, two of my employees, one of them being the accountant, were missing since 22/7/2019 and untraceable till date. It is pertinent to mention here that because of the threat perception to my life, I have been granted a license of 9mm pistol for protection of my life and security. Further, due to imminent threat to my life and my family, I was provided with an armed police security personnel since 2007, and the said deployment has been continuing. In the year 2014, in fact, I was provided with 2 armed police security personnel, and thereafter, again, 1 armed police security personnel was deputed on my duty until 20th of July 2023. However, most surprisingly, without any intimation on 20th of July 2023, the said armed police security personnel was abruptly removed from my duty, during rendering me to vulnerability. I have no knowledge as to why he was removed from my duty when I have been religiously following the directives issued by the SP Security, Assam, for the protected persons to be followed to ensure the safety and security and coordination to be maintained with the PSOs as attached to them. It is to be mentioned herein that I have upcoming projects including aviation services to the Northeast region, which includes frequent travel to the sensitive and militant areas, active areas. Therefore, there is reasonable apprehension of possible targets and threats and of the said outfits to me. There is imminent threat to my life, and as such, the abrupt withdrawal of the armed security police personnel from my duty has been causing immense mental pressure on me. My free movements have been restricted, and now I apprehend imminent threat on my life and liberty. Considering the above, the armed security personnel may be deployed back to me at the earliest, otherwise it shall cause great prejudice to the undersigned, as I am under constant threat and imminent danger is prevailing over my life. Under the circumstances above noted, it is therefore humbly prayed that your honor may graciously be pleased to deploy back the armed police security personnel for protection of my life and liberty. Lordship will kindly permit me to submit this. The representation is absolutely clear and is quite correctly he has given the statements in the representation. While he wants restoration of the PSO, if we read the minor representation between the lines, he is on the one hand talking about the overall scenario. That is why there are repeated indications in our affidavit that overall scenario has improved. Now, there is no connection, no linking between the overall scenario and his personal life and threat to his personal security. There is nothing. On the one hand, he's saying they are active, and the other, he says, I am apprehending. Where is the, because if on these grounds, my lord, a PSO is provided in every businessman will come to the lordship and then say that I am having a huge business activity and then nature of work in which I am involved. What is the nature of work? You are not indicating because of which the threat is there. You are only saying that I am doing some work and I have a threat perception. My lord, here is a case, West Bengal case did not have any SOP. We are concerned with an SOP. We, as your lordship has said, your lordship will only see the decision-making process. Now, if we have followed the SOP and if they are not saying that SOP has not been followed, where is the question of giving a PSO at this stage when he himself is saying that there is no threat perception? Well, I am repeatedly submission at the cost of repetition. I am saying that he is not saying in the writ petition that because of this incident, because of that
That we
event.
have noticed, yes. What about
So,
the
no.
own cost PSO?
Own cost PSO, my lord, here in Assam, PSO nowadays all PSOs are provided own cost. Earlier he was granted. Now under the SOP, it is all on cost. Everybody is paying in the order which they are on which they have placed reliance in the interim order. In there are 6 to 7 cases all tagged together. In all those cases, all of them are paying. All of them are paying, and on the basis he was earlier granted, but nowadays nobody is granted. My lord. He was granted earlier, but my lord, if his case is that in 2007 and 2014 there was some threat perception on the basis of which I was granted. Today he has to show that there is some, because SSRC makes a review after every 6 months. A person who is having a threat perception today cannot say that I'll enjoy it for throughout my life. Then where is the question of making a regular review by the SSRC? SSRC itself, this SOP itself says that they will make the review. And if they find there is no threat perception as on today, it will not be granted. And in his case also, my lord, not because of any individual threat perception that he was granted. It is because of the overall scenario. And he is placing reliance on the same incident. These things have improved. That is why we are saying that things have improved. And you do not have any individual threat perception from any individual incident or from any individual organization. He is not saying.
Which are the orders?
My lord, my lord. And about the Mitra's case, my lord, Supreme Court, my lord, lordship will kindly see 2 things are there. One, in paragraph 10, my lord, there is a clear-cut concession on behalf of the state of West Bengal, which we are not making here in this case. Secondly, there is no SOP because they said the procedure in paragraph 9, the procedure adopted is to call for a report from the SP. We have got a detailed SOP, my lord. So paragraph 9 shows that there was no procedure. We have a procedure by way of an SOP. Paragraph 10, there is a concession, and my lord, paragraph 11.2 on which they are placing reliance to say that on payment they will get it. My lord, that is not a ratio in that case. No law has been laid down as such. And the other 2 orders, my lord, on which I am placing reliance. And regarding gun license, my lord, argument has been made that when a person has been issued a gun license, that means he has a threat perception. My lord, lordship will kindly see there are 2 things. This license he applied while he was in Delhi, and based on the assessment that might have been made by the authority there.
No, that argument you need
My
not label.
my lord.
They are not considered. Gun license is a different thing.
My lord.
In
And
fact, on a lighter vein,
my lord.
few days back, we were conducting interviews of some judicial officers.
My lord.
And we found that there were some, of course, this is not to do anything with this case.
My lord.
So he was possessing a gun license. So question was posed that as a judicial officer, why do you need a gun license or to carry a gun? Can't disclose the answer he gave, but
Right.
it was really interesting. Anyways, so what is this order 25/8/2023?
And lordship, in both these cases, SSRC ultimately when recommended that there is no threat perception, this honorable court did not interfere and did not grant any order directing us to provide PSO even under the payment.
Yes, all right. That's all. Yes,
Ma'am.
Mr. Goswami. reserve the order.
Well,
The parties need.
there are three things. First, in none of the cases, the highest body, which is this SSRC, there is a division of opinion. Two persons of that group, it is supposed to be a collective decision. Two persons think that the threat perception continues. I don't want your lordships to go who is right, who is wrong. That's not within the parameters of your lordships, as I understand it. What your lordships find from what is being produced as an extract of that review committee is that two persons your lordships find who are local, SP and Commissioner of Police, they opine that there is a threat perception. Now, there can be two situations. Your lordship can have a look at page 74 once more.
No, that is the reason, Mr. Goswami, I
Yeah.
was asking you, there is a affidavit filed on behalf of respondents 1, 2, 4, 5, and 6.
Miller,
And therein the stand has been clarified that whatever the stand is, right, wrong, whatever the stand is, they have taken a stand in the affidavit. You don't seem to deny that stand.
no, that affidavit was supposed to be filed on 12th. Have they
No, no, in
taken?
the earlier one,
No.
affidavit filed on 1st September 2023.
That we have dealt with, no. No, that affidavit is, your lordship is referring to the first affidavit? No, we have not replied to that because your lordship see to paragraph 4, and I have shown your lordship the pleadings. Our specific pleadings are part of paragraph 4. There are no comments. I have placed paragraph 16 and 17. They are admitting all that we have said there. I am not on his perception at the moment. Before the Supreme Court, the report of the SP was against him. There is no threat. Here, your lordship is given an affidavit or on affidavit, an extract from that meeting of that highest body, where two persons say that the SP and the Commissioner of Police, that there is threat perception. That's the difference between all these cases. In Vishwanath's, the Calcutta case, before the Supreme Court, the report of the SP was that there is no threat perception. And in spite of that, your lordships have noted in your lordship and quoted paragraphs 10 and 11 from that judgment, where it is said that notwithstanding that report of the SP, he can have his own perception. And therefore, an opportunity you have to give, and he can be given on payment. And your lordships have, in that order, by an interim order, has granted that liberty. And we are here, hailing that for all these years, and you abruptly withdraw, and now you are showing a proceeding of the highest body, in which two of these local heads are saying that there is a threat. So forget my perception, go by their two persons. It's not a question of majority rule here. You are dealing with the life of a man. If two of these police officers think, there is a sense of threat, would the court not take into account that fact? It is not a question of majority and minority, my lord. We don't know. We don't know the future. We don't know who is right, who is wrong. Suppose nothing happens, it's okay. Suppose something terrible happens, we'll all regret. Because your lordships, the court can't redeem that situation. If that happens, why would the court not take an action? I am not asking your lordship to judge who is correct, who is not correct. I am only suggesting that kindly see what is flowing out of the records. Two persons, heads of the district say there is a threat. Would the court not give him an interim protection after all these years which he is enjoying? It's a collective decision. Two layers have said that yes, there is a threat. I am not saying your lordship to decide who is correct, who is not. Why did the Supreme Court not accept that? They have not said anything. They said that you have to take the perception of the man you are dealing with. And if he applies, notwithstanding everything we have said, you have to give him protection at his expense. That's what your lordships have mentioned. You have quoted in your lordship's order, these two paragraphs. What does it mean? There is a report of the SP in that case, and he said, concession, you are going to the Supreme Court, it's an appeal by the state of West Bengal. If you have considered, would you go to Supreme Court against the High Court judgment? What is he talking about concession? And kindly see, apart from anything else, Miller, apart from anything else, kindly take into account two facts. Your lordship is not deciding the matter. Your lordship is taking note of the process of review, where your lordships find two of the heads of the district say there is a threat person. The question is, it's a collective layered decision. If you find two persons have said that, would the court not take into account this very...
So at the end of the day, what is the order you are seeking in this?
I am only saying, if your lordship is hearing the whole matter, that is one aspect. If your lordship is hearing the interim matter, then...
No, the whole, I'll reserve the order, final order.
Final orders, then I will say two things. If this affidavit is supposed to be against me, last affidavit, then, my lord, because the first affidavit does not. I have dealt with with the allegations, they are admitted by them. Paragraph 4, read with the paragraph 5, your lordship has seen that whatever we have alleged in paragraph 16 and 17, that was an admission. There is no question about it. Therefore, I need not reply to that. But if this is coming, I have two submissions. There it is beyond the time given. They have not taken any permission to file this affidavit. 12th was the date fixed for filing the affidavit. They are filing it today, giving us a copy today in court. That is one. Two, the decision was taken in January 22. The impugned order is August 23, July 23, after a period of 1 year, 6 months. You talk about 6 months review. What is the review? What have you got before your lordship? You are asking for a still cover, have it. But have you produced any material to show that this order or this proceeding which was taken on in January 22, we have reviewed again after 6 months? This is our review. Have they done that? If they have not done that, then how do they explain this delay? And how do they explain that if two of your persons think that there is a threat perception, what is your material to think by PRZ that there is no threat perception? What is that material? Have you been given that material? No. And somebody is fighting for his life. And he wants that I should tell him everything. You deput the man, that's why Supreme Court said that you evaluate his threat perception. Go to him, find out. You are giving natural justice for all occasions, and you are not even thinking of this man who is threatened and who comes to the court to say that I am being threatened, the abrupt withdrawal, no information, and the proceedings support him. Two of the officers' opinions support him. What would the court do then? Say there is no threat, therefore he is not to be given.
What is the order you are seeking here? That's the question I'm asking.
Because I am seeking a protection from your lordship, which was available to me, continued, and even these proceedings, two persons support it. It is not a question of deciding who is
So
right. who is wrong.
therefore, if I've understood your submission.
Yes.
You are saying that since two persons at some layer has said that it be continued, issue a mandamus to continue it.
I am not even saying that. I am saying that your lordship will not decide who is right, who is wrong. Your lordship will approach the matter from the point of view of the right to life. If two of your heads of police of that highest body think there is a threat, would you ignore it? That's the whole
I am
crux.
asking you. this
I'm not
question,
saying you means the court. I am asking myself.
What is the
would I-
order?
would
What
I-
is the
there is
mandamus you are seeking here in this proceeding? This will be the final order here, this way or that way.
Then
What is
my
the
lord,
mandamus?
your lordship will continue with the protection.
Hmm.
If necessary, if your lordships want, your lordship will follow what has been done by the Supreme
Continue it
Court.
till how long? For how long?
Your lordship will then follow the procedure of the Supreme Court that you will identify a person and give a representation with all your details, and they will let them decide whether that check continues or not. Paragraph
So
11.
you are basically seeking an order directing them to review.
They themselves said they will review in 6 months, every 6 months. You have done it in January 22, and your order is of July 23. 6 months already expired, you have not reviewed. And he is before your lordship. That's the situation with two persons saying that yes, there is a threat. Can the court ignore it? Can any reasonable man ignore it?
No, the court cannot ignore it.
Correct,
Provided
that's what
there
I'm
is-
saying.
Provided there is some realistic basis for the threat. What is the
Realistic-
basis? That's what I'm asking.
No, realistic basis is this opinion of the person concerned, who is a layered person of the review committee. Forget my perception. I have said already that I am imminent danger I am facing because of that. So what did the Supreme Court do finally? And what did your lordship do in this case? Lordship protected. Supreme Court
That's right. We are trying to figure out what kind of a principle would be.
principle
applicable.
is that it cannot be infinite, I understand. But there has to be a reasonableness about what you do. You have a power, it's a very ancient duty of a state that the primary thing is to provide security to your citizens. Therefore, when he comes and shows me lot that he has been getting this protection, suddenly it is withdrawn. First of all, my lord, if there has to be some discourse, something that look here, that we have given you this, there is no threat perception, you are free. That discourse needs to be done, my lord, in a matter of this type, my lord, where you are yourself giving protection, central government is giving a pistol not given to a civilian. Therefore, it's not just a gun license. It's a, they're.
Giving a pistol does not justify continuance
no,
of
but-
security cover. That
You see at page 42, their order. It is on the basis of a threat perception of the person.
there are many people who have a pistol license.
No, I am not in that.
Can we go into that
No,
aspect?
I am not in that. I am saying,
We can't even comment because the Union of India is not a party here. We
no,
don't know
I'm
why
not,
they.
Union of India is extending my protection
Correct.
till 26.
So pistol license.
No,
being a
pistol
justified
license,
ground-
as I showed your lordship on page 42, it is on the basis of a threat perception. That is.
Which existed at that point of time.
And it is renewed
Correct.
till 26.
So are you saying that as long as the pistol license is renewed, the
No, I
government
am
is
not
bound?
saying anything, Miller, on that, in that manner. I am saying these are the factors which led to a protection. From the state side, they gave a protection, that is undoubted. They thought, I need
No,
protection.
that's right, Mr. Goswami, the
Central
questions you are raising are indeed very serious
Yeah,
because it has a facet of Article 21.
absolutely.
But at the same time, the court also has to be very circumscribed in these matters
I agree.
because
Your lordship will not give
seeking
it.
a security cover has many dimensions
I quite
and
see.
many
I
underlying reasons.
entirely agree with your
So
lordship on that.
unless the principle is threshed out,
Principle is this, Miller. If there is a threat, even Supreme Court said that his own perception is very vital.
correct. So the reason why I'm
True.
posing the question is I'm trying to get as much as possible from your expertise on these.
Miller, I can't be better than your lordship's wisdom.
It's a,
But my
the
humble,
court has the benefit of a treasure trove of knowledge
no.
standing, so
it's
I
a-
would not like to miss out on this.
Yeah.
Therefore, the questions.
Miller, it's a, to my mind.
Order will pass on the
Yes,
basis of our
but in
conscience.
my
That's another
very
matter.
humble submission, Miller, every case will depend on its own
Correct,
facts.
correct.
That is number one.
Correct.
Two, it certainly concerns the right to life in a way. Thirdly, there has been a long period of protection given. Fourthly, your highest body, two of the people thought it is supposed to be a collective, your own PSO, your own procedure says it's a collective decision. It's not a right or wrong, majority or minority. Two individuals at the highest rank think there is a problem with this ban, threat. Therefore, it should continue. That is done. You don't review after 6 months. It continues.
All right, Mr. Majumdar, we'll draw curtains to this now. The only factor which we will consider from either side is because the court does not have the expertise to deal with these matters. The court will see whether
Yes,
there were the considerations were germane.
yes.
The seal cover you have given does not disclose anything. It only shows the name of the petitioner at particular serial number so and so and a comment to be withdrawn. That certainly is of no moment for this case. Now, what Mr. Goswami is urging is that there are inputs available on record which suggest that there is a threat perception. So therefore, this stand in the affidavit that there was no threat perception belies the stand of the respondents on the face of the record. So then the only question would be that you deal with his question and take a decision. That's all. Deal with this issue and take a decision. Press
That can
decision.
be done, but
You do it
otherwise,
in 2 weeks,
that can be.
2 weeks, 3 weeks.
My lord,
Until then,
otherwise, my lord, even the
No,
argument
where is the Supreme
that
Court
withdrawal
judgment?
recommendation was about 1.5 years back. What is your reply?
no, we
Well,
can't comment on these
No,
things.
I have got a submission lawfully
The-
considered.
Where is the consideration
Well,
of the inputs received from the
My lord, all
commissioner?
inputs have been considered.
Where is it? You know,
Well,
affidavit, you
My
say
lord,
that.
in the writ petition, there is no input at all from his side. Let's see, because of this, I am apprehending
No,
it.
no, Mr.
My
Majumdar,
lord,
see
my lord.
page number 74,
My lord, Page number,
the document annexure A,
page, my lord,
that is the page 74.
7.
74. This is your document, is it not?
Yes.
It is your affidavit.
Yes, yes. Regarding this, I have made a very clear submission, lot will consider that.
So where are the materials to show how this has been dealt with?
My lord, the PRG sits with the materials.
Where is the material to show that? He has come to the court. We would just like to see that they have dealt with this input and then taken a conscious decision. That's all.
And PRG takes everything they should not write on paper, but they take into
Nothing.
consideration.
Where have they taken note of this? That's all you have to show,
And
Mr.
PRG has recommended that we are recommending withdrawal.
The point here, the petitioner's case lies on a very narrow thread. The court agrees with almost all limbs of your argument,
My lord,
except that,
yes.
see, the process has to be objective and transparent.
If your lordship has.
Because only because SSRC is doing it, that doesn't mean it is not amenable to the
Not beyond
court.
judicial review, my lord.
Then
That I'll not argue.
What he is urging again and again is that, I don't know whether it's a threat perception or not, but your officials are saying there is a threat perception. So how have you decided on
Officials at
this?
the lower layer is saying,
What lower-
PRG is of higher layer, my lord. They are entitled to.
In
my lord,
what manner the PRG has taken note of this?
my lord,
We want to see
PRG
that.
my lord, then in that case, your lordship will direct the PRG to take a fresh decision. My lord, based
Take
on-
a fresh decision.
Otherwise, my lord, my submission before.
We'll ask
lordship-
him to in
What-
3 days,
my lord,
submit
what-
a fresh,
my
listen,
lord,
please
how-
listen, please listen.
I'm sorry.
Within 3 days from today, let him submit a fresh representation indicating what are his threat perceptions. By substantiating it,
Yes.
let the PRG take a fresh decision on that. And then pass whatever orders.
Fine.
You may continue with the decision or not. Till that time, you extend the cover to him. That's all. You do it in 3 weeks' time from today. Heavens will not fall.
He has not been able to make out a case for any interim order. That much I'll.
No, there's a final order here.
Yes,
No interim order.
Right.
What do you have to say on that?
my lord. We'll consider a fresh, my lord.
Take a fresh decision. It could
And
be
why will we not
against
eat-
him also.
My lord.
The only aspect is here is that because it has got a facet of Article 21,
Absolutely,
the
my lord.
court would be very cautious and circumscribed in both sides. The court will not take a sweeping decision either in his favor or against him,
No,
not against the state.
no.
The only thing the court wants to see is that this has been done on the basis, on the touchstone of objective criteria and proper appreciation of inputs that are present. These documents you have placed before the court does not throw any light on that. On the contrary, your own affidavit shows that there is some input that there is threat perception. We only want to know how this has been dealt with. At the moment, 2 successive affidavits does not throw any light on that.
My lord, we have-
Your seal cover,
My lord,
does
we
not-
have, at least in the affidavit, we have not entered into the manner in which the PRG has acted, my lord. We don't know that. It has come in seal cover. Our instruction was that PRG is the higher authority.
so order reserved.
Milord, if they can't explain on what material PRG is taking, if this is the concession they are saying, then obviously, Milord, I am entitled to the restoration of the protection, and then
My lord,
they
will kindly
can
see the
review
SOP.
and do
Lordship will
whatever
take
they
a look at
like.
The SOP also.
Ah.
About.
Mr. Mojumdar,
Well, this
this
is
order
relevant.
will not go into anything else. If you
No, about
If
the
you-
payment basis,
if you
my lord.
decide to,
No, my lord, one
Always
submission I have to make about the payment basis grant of PSO. Under this PSO, my lord, which is my lord, operating from March 2022,
Mhm.
only on payment basis a PSO can be provided. The argument that earlier it was free of cost, because in respect of now under the SOP, in respect of persons who are apprehending anything and he's a businessman, for him only on payment basis.
absolutely, absolutely.
So the argument that
I
earlier it was.
am indicating,
My lord,
I am indicating the contours of the order
my lord.
just for the benefit of both sides, and I'm not going to change it. The only issue we will observe in the order
Right.
that he has not been able to make out a case showing what is the real fact on which the threat perception exists. Therefore, on that count, the court does not find the petitioner's case to be sustainable.
Right.
But the other important aspect is that he has been given a protection on an assumption that there is a threat perception. It has been withdrawn. Now, the state says that this process has been preceded with a proper scrutiny by SSRC.
Right.
And the record shows that there are inputs received by the SSRC which suggest that he has threat perception. These inputs may or may not be actionable. These inputs may or may not reflect the real state, but we don't know how these inputs have been dealt with. It could be a case that it has been mechanically brushed aside, or it could be a case that these
Decision was
inputs have been
correct.
acted upon, examined, and then a decision is taken.
Possibly indicating.
Both are possible, but it is not clear what has been done. So there is a strong possibility that these inputs have been mechanically brushed aside. So this gives rise to a genuine grievance for the petitioner. He has a right to be assessed. If you are assessing, then you must assess it properly. You can't say that we are the assessing authority, but we'll do whatever we feel like.
No, no,
That can't be the stand.
no, we can.
So till such time you review it, you provide him PSO on cost.
Yes,
And you're open to pass taking any decision after a proper consideration of the threat perception.
We'll
You
take.
do it
this.
within 4 weeks, 6 weeks, whatever you want. to
yes.
do. You do it within 1 week, your call.
We'll take the decision, but in the meantime, he's not entitled in my humble
No,
submission. Dr.
no,
Lordship may-
after
We'll see
that
that.
finding not to
Yes,
give
there is
protection
another
to-
matter, Mr. Saiwala.
And one more thing,
That's
Milord,
all.
your lordship has said, may add, because in the affidavits, two affidavits, they have not produced any document or any material to show what was the
Mr.
consideration of
Goswami,
PRT.
with
That
due
is
deference to your standing and skill in the matter, the court is not convinced on merit that
I
he has
am not
made out a
arguing
case.
on merits,
It is
Milord.
only on the procedural
I
aspect
quite
that,
see, I am not arguing on merits.
because
for your lordship.
if this aspect of the matter goes
They will decide.
unappreciated by the court, then it may send a wrong signal.
No, no.
That's
I
the
am
only
not-
reason.
I am not saying that your lordship should decide. What your lordship should indicate, I was trying to add because your lordship said that I am making it clear. Here, PRG's documents are not before your lordship at all.
This
That is
correct,
all
they
I
have not
wanted to
produced
say.
it. They have not produced it.
That is
So
all.
therefore, we will apply the principles of section 114G
That is all
of
I
the
said,
Evidence Act,
nothing
that
else.
they did not disclose it despite an order of the court,
Yeah.
which goes to show that these have not been
Yeah.
dealt with.
That's right, that's what I,
If this aspect was dealt with, the outcome could very well have been very different in this
that's
case.
all I said.
All right,
And Milord,
you'll get the order tomorrow.
My lord.
restoration should be done. Deeply.
Tomorrow you'll get the order. You can inform them, his cover on his own cost. Restore
Yes,
it.
yes.
But he gets 3 days time to submit a representation
Let
before
it be
the
3 weeks now. Now that he's getting, let it be 3 weeks.
3 weeks.
Huh?
And,
Three
and
weeks.
Uh-huh.
No, no, I mean.
Then 1 week for us to
1
find,
week for him, and within 3 weeks thereafter, let him decide.
very good,
For that period,
he will get the.
show some magnanimity.
My lord, difficulty is, if this is the manner in which a person gets, everybody will come. I am doing a huge business, I have got.
Difficulty is, don't do these things. If you are dealing with the matter,
My lord.
this is in a state like Assam where there has been history of terrorist activities,
At some
People
point in
who
time,
are-
it was there, it was there.
who have a fixation to this PSO business, they will catch hold of any lead you give them. Why do you do it? Why is it officers are giving recommendations in
Yes,
favor
yes.
of the
There lies the
protective
difficulty.
and you don't deal with
I
it?
have understood,
What is the reason?
yes.
Milord,
They are compelling the courts to
Right.
pass orders on judicial canons.
Absolutely, absolutely.
What option does the court have?
I have not troubled your lordship with this, which my esteemed juniors have found out from. There is an organization monitoring every part of the world as it appears, including Assam. The incidents from July 30.
He got the complaint to the CBI. And CBI also forwarded it to the CBO, saying
Okay, so
that,
we'll hear it then.
no, not, I'm withdrawing my,
Achha.
I am withdrawing with liberty, my lord, to approach the alternate forum, including police. That may.
This is up to him, my lord, but
That
Mr. J.N. Sahiwala, that is senior counsel assisted by Mr. N. Sahiwala, learned counsel appearing for the writ petitioner in this case submits that he has instructions to withdraw this writ petition with liberty to pursue appropriate legal remedy as may be permissible in the facts and circumstances of the case. Mr. Kiran Chaudhary, Learned Senior Counsel.
I'm
Assistant
appearing for
Prof-
5 and 6.
Mr. H.K. Das, Learned Counsel for the respondent numbers 5 and 6, as well as Mr. P.K.K. Parashar, Learned CGC appearing for respondent numbers 1, 2, and 3, submit that 1, 2, 3, and 4, submit that they would have no objection if the writ petition is permitted to be withdrawn with liberty as prayed for. In view of, is there any interim order here? In view of the above, this writ petition stands withdrawn, disposed of on withdrawal with liberty as prayed for. That's it. Mr. Sahiwala, the issue that was confronting, now that the matter is gone. You see, the courts will have to always be conscious of the fact that you can't allow perceptions of individuals to be driven with the help of writs issued by the 226 court. If that is allowed, then it will create a
Certainly, my lord.
chaos. But if it was a case that he had lodged an FIR which had got ingredients of a cognizable offense, the police is refusing to register it. And to that extent, the courts in that case would be justified in issuing mandamus to compel the authorities to perform their statutory duties.
But my lord, in Supreme Court, in that case, you even deprecated that. Supreme Court has said no to not 226. Go to 156 straight to the magistrate.
Of course.
Like
Of course,
it's a
no, that
Saikari Basu's case.
so that's correct. That will also depend on facts, but if at all. Otherwise, 156(3) is the option. But this is his perception. He feels that there is corruption. So he wants to take over the reign, and how? With the assistance of court orders.
And look at the conduct, my lord.
What happens tomorrow if the thing goes into a trial and there are observations of the 226
Exactly.
court?
Hmm.
So these are petitions which should be dismissed. I was contemplating a cost of 1 lakh. Your client, you have saved 1 lakh rupees for your client. Let me tell you that. We can't entertain these things. Things are going too far.
Madam.
While there can be no limits for the constitutional court to pump in life and freshness into the constitution, there are limits to which we can exceed the limits of the constitution. That this court will always keep it in mind. So any other matter? All right. Yes.
Item 4. Item 4.
Ready for hearing? Ready for hearing?
Excellent.
All right.
By the circle officer. And the petitioner number 2 and 3, ma'am. In respect of the plot-
Just 1 minute,
Fine.
Mr. Das. So what happened? Your client has already been evicted.
Evicted, my lord.
Huh?
Evicted.
So what order you want now?
Thereafter, my lord, this honorable court pass an interim order, my lord.
Hmm?
This honorable court pass an interim order.
Hmm.
Can you fill the interim of the my lord?
Interim order dated?
That is my lord, I will.
What is the date of the interim order?
My lord. Interim order dated 24/9, 23/9/2013, my lord. As an interim measure, not to allow respondent number 6 to 9 to raise any construction over the plot of land measuring 5 acres covered by Miyati Pata number so and so.
Who is in possession of the land now?
Now in possession of respondent number 6 to 9.
You go to civil court. In the meantime, we'll make this interim order absolute. That's all. So if declaration of title and for recovery of possession, that is the only way out.
My lord.
Nothing else can be done. Because you have already been evicted.
Evicted.
Now, restoration will not be possible in writ petition. You have to get an order in the civil suit. Because there is Miyadi Patta land also.
Miyati Pata.
So we'll pass that order. What else? And the interim order will be made absolute.
But they have already constructed my lord on basis of the
That
respondent.
you have to ask for then recovery of khas position. You have to make the prayer in your suit.
My lord.
The writ court cannot direct demolition of construction. If it was prior to disposition, then maybe we could have stayed. Now the only relief you can get is from the, but we'll make it status quo will continue. So from 29/3/2013, status quo will continue.
Right.
And if they have made constructions during this period, you
Yes.
can show it to the civil court. It has to be demolished,
My lord.
right?
My lord.
You are for whom?
For 6 to 9.
What do you have to say? Huh? Where is the impugn order? Last, where is the impugn order? Yeah.
In order dated 23/9/2013, my lord.
Huh. Page number?
Annexure is the eviction notice, my lord.
Annexure?
A. There is no enforcement case and the date is also nil, my lord.
Where is the order of the circle officer which you are challenging? Page? So that is the original notice.
Yes,
They
yes, yes,
They
yes.
submitted a representation, but this,
They submitted, they have not passed any order. In this case, my lord, respondent number to file affidavit, my lord. Lordship kindly peruse their affidavit in paragraph 4, my lord.
So what have we got to say? Let him, we relegate him to the civil court
Yes,
and
Lordship.
the interim order will be made absolute, man. Until decision in the civil court.
Yes.
But you will get only 3 months time to file civil suit. If they approve the civil court within that time, the interim order will continue till a decision, final decision in the civil court. Otherwise, it will stand vacated. If they don't file the suit within 3 months from today, it will stand vacated. Okay, done. Heard Mr. A.J. Das, Learned Counsel, assisted by Mr. G. Rengma, Learned Counsel, appearing for the writ petitioners. Also heard Ms. S. Borua. Mr. J. Henry, Learned Standing Counsel, Revenue Department, Assam, appearing for the respondent number 1, Ms. S. Borua, Learned Government Advocate, Assam, for respondent numbers 2, 3, and 4, and Mr. A. Khanifer, Learned Counsel for respondent 6 to 9. None has appeared for respondent number 5. First of all. The writ petitioners herein claim that they were in possession in respect of a plot of land measuring more or less 8 lectures covered by Miadi Patta number 23, Dag number 1296 of village Konwar Khahi, GHAHEE, Gaon, under Moja Dhokwa Khana in the district of Lakhimpur. Out of the aforesaid 8 lectures of land, 3 lectures of land was Sarkari, and the remaining 5 lectures was Miadi Patta land. Due to a apparent land dispute between the writ petitioners and the respondent numbers 6 to 9, the private respondents had made a complaint before the subdivisional officer, Dhokwa Khana, that is the respondent number 3 herein, with a request to evict the petitioners from the plot of land in question on the ground that the petitioners were encroachers in respect of Miadi Patta land covered by Dag number 1296 of Patta number 23 of village Kunwar Gahi, Gaon, under Moja Dhokwa Khana by constructing a cow shed. The respondent number 3 had forwarded the complaint to the circle officer, Dhokwa Khana Revenue Circle, that is the respondent number 4, for initiating necessary action in the matter. Consequently, the respondent number 4 had issued eviction notices to the petitioner numbers 2 and 3, directing them to vacate the land measuring 6 lectures, which included land measuring 3 lectures pertaining to Sarkari Dag. Sarkari Dag, full stop, failing which they would be forcefully evicted from the land in question. Full stop. Being aggrieved by the aforesaid notice, the petitioner number 2 had submitted a representation before the respondent number 4 for recall of the order. But the said representation was not considered by the competent authority. Subsequently, the petitioners were evicted from the plot of land in question on 6/9/2023 at the instance of the respondent number 4 with the help of police. after demolishing the cow shed and the boundary wall of the land. Full stop. Thereafter, the possession of the land was handed over to respondent number 6 and 9. Full stop. Aggrieved by the aforesaid action of the respondent number 4, the petitioners had approached this court by filing the instant writ petition, wherein the learned single judge, while issuing notice of motion, had passed an interim order dated 29/3/2013, restraining the respondent numbers 6 to 9 to raise any construction over the plot of land measuring 5 lechas covered by Miadi Dag number 1296 of Patta number 23 and 3 lechas of Sarkari land situated at village Omar Gahi map under Moja Dhokwa Khana in the district of Lakhimpur. Full stop. The interim order dated 23/9/2023. Has it been extended?
Not yet.
Huh?
Not extended.
Not extended. Not
Yes.
extended, then it is gone. It is not required, the interim order of so and so for district Lakhimpur. Full stop. The basic argument of the petitioner's counsel is that the land in question having included Miadi Patta land, the respondent number 4 did not have any jurisdiction to issue eviction notice, nor was he authorized or competent under the law to evict the petitioner from the Miadi Patta land. Notwithstanding the same, the respondent number 4 herein had usurped the powers of civil court and evicted the petitioners from the land in question by putting the respondent number 6 to 9 in possession of the property. First up. Ms. Borua and Mr. Hendik Leonard SC Revenue Department Assam and Ms. Borua Leonard Government Advocate Assam have argued that there is a civil dispute by and between the petitioners and the private respondents, which needs to be resolved in the civil court, and therefore the relief as prayed for in the writ petition cannot be granted to the petitioner. Similar is the stand of Mr. A. Kanika, Learned Counsel, appearing for the respondent number 6 to 9. First up, after going through the pleadings available on record and on hearing the submissions made by Learned Counsel for the rival parties, this court is also of the opinion that since it is the admitted fact that part of the land measuring 8 lechas constitute Miadi Patta land, the petitioners cannot get possession of the land unless they succeed in obtaining a decree from the civil court by establishing their right, title, and interest over the land. Full stop. If that be so, I find force in the submission of Learned Departmental Counsel that this matter deserves to be relegated before the civil court. Mr. Das as well as Mr. Kanikar have also agreed to the same proposition. In view of the above, without expressing any opinion on the claims and counterclaims made by the contesting parties in this proceeding, this writ petition is being disposed of by granting liberty, by granting 3 months' time to the petitioners with effect from today to approach the civil court seeking appropriate decree so as to get back possession of the land in question. First up. If the suit as permitted by civil suit as permitted by this court is instituted within 3 months from today, then the same be decided on merit in accordance with law after proper service of notice upon the opposite party. First of all, until such time, the suit is disposed of on merit. Interim order dated 23/9/2013 passed by this court shall continue to hold the field subject to you write like this. The interim order dated 23/9/2013 will continue to hold the field for a period of 3 months from today, permitting the petitioner to approach the petitioners to institute the title suit along with appropriate application for temporary injunction, if so advised. Read petition stands disposed of accordingly.